Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law, and this will be what we're commenting on today. Melissa Lucio was 2 days away from dying by lethal injection in 2022 when a Texas appeals court halted her execution in order to permit her attorneys to argue actual innocence and prosecutorial misconduct. We've discussed it a lot on here on this channel about how every defendant is supposed to have access to all of the evidence in the state's possession that could potentially be exculpatory. That's the Brady rule. Now, that rule has saved a lot of people at the outset of a case from ever getting to trial because defense attorneys armed with that information were able to convince the judge that a trial shouldn't be held. But in many cases, the only time that rule really has any teeth is when it's violated. And when it's violated, it tends to be something that gets cases reversed. And it appears to have been violated in Lucio's case. Last week, a Texas judge made the determination that the woman who was set to be executed was factually innocent of the crime of capital murder. Senior State District Judge Arturo Nelson said that prosecutors had provided false testimony and they had suppressed evidence in prosecuting Lucio. In addition, scientific evidence that wasn't available at the time showed that there was a great deal of controversy about whether or not she was even guilty to begin with. So that often happens when the science changes and there are some doubts about the forensic evidence that was gathered and what it means. In this case, it may have something to do with the fact that the medical experts testified that the child was beaten and abused when the evidence could very well have supported a fall down the stairs, which is what Lucio had told authorities had happened. So because of this, because of the new evidence that they had, new factual scientific evidence that helped undermine the state's case, and because the state had presented false testimony, and because the state had presented incompetent evidence that should never have been admitted, the judge recommended that her conviction and death sentence be overturned. Now, that doesn't mean necessarily that she goes free. What it means is she probably gets a new trial. But he did conclude that she was factually innocent, so maybe in this case it actually does mean that she goes free. He wrote that the court found that Lucille had satisfied her burden and produced clear and convincing evidence that she was actually innocent of the offense of murder. And as I mentioned earlier, that makes a great deal of sense, especially when you conclude that if indeed she did fall down the stairs, if the child, the 2-year-old that she supposedly murdered, had in fact fallen down the stairs, there was never any crime at all. That's just a tragic accident, and it probably tore the heart out of this poor woman anyway. In this case, the judge issued a 62-page order where he went through all of the facts that were brought to light in the hearing on the matter. And he had signed that order back in October, but it wasn't made public until last Thursday. Now, Lucio had long maintained that she was factually innocent and that her daughter Mariah had died of a closed head injury, and that the head injury was caused by an accidental fall down a steep staircase. And that fall had occurred only 2 days prior to her death, which of course gave her time to bruise up from tumbling down the stairs. The state took the position that she'd been abused and neglected and that she had been beaten to death by Lucio. And of course, they based that on the bruises that came from the fall. Now, you would think that the judge finding that she's factually innocent would perhaps mean she'd get out of jail, but that's not the case. Now the case is going to go back to the state appellate court because this was on direct appeal. The first time the appellate court sent it back to the trial judge to make additional findings, and now it will go back to the appellate court to have them make the final decision. Now, given that in most cases appellate courts will defer to factual findings made by a trial judge, that's a pretty good indication that Lucio will at some point be taken out of prison. The appellate court, however, is the one that has to make that final decision. There's no timetable. You're not going to get a ruling next week or next month. It probably will take 2 or 3 months to get this through the system, and then you'll probably get a ruling. Lucio had gotten a lot of support from a lot of different people. Kim Kardashian has been really active in trying to help free people from being wrongfully convicted. The Innocence Project was involved. A bipartisan group of Texas lawmakers were involved. Lucio's family, indeed Lucio herself, were quite pleased with the result. They said that it was the best possible news they could have heard. They had been praying for their mom and that she would be home soon, and I imagine they are probably still praying. This is just another example of the kind of excellent work that the people at the Innocence Project do. The director of special litigation there has said that Lucio had been sent to death row for a crime that had never even happened. In other words, an accident isn't a crime. Now, the Cameron County District Attorney's Office, that's the group of prosecutors who actually prosecuted Lucio the first time around, couldn't be reached for comment by the media, and I imagine they're probably still licking their wounds and trying to figure out if the conviction does get reversed, whether or not they're going to have enough evidence to retry her, especially given the fact that several pieces of their evidence were found to be incompetent. But what's really horrifying about this, assuming that the judge is right and that she is factually innocent, this was a woman who was 2 days away from execution in 2022 and was very nearly killed by mistake. Only a last-minute stay of execution by a Texas Court of Criminal Appeals prevented her from going to her death. Now, Lucio's lawyers brought a number of facts out that weren't before the original court. First of all, that the prosecutors had presented testimony that was false. Now, whether they presented knowingly false testimony or not is a big question. If the lawyers did not know that the testimony was false, they really can't be blamed for it, other than perhaps for having done a shoddy investigation. But if they knew that the testimony that they were putting up was false, that's an ethical violation, and they could and should lose their licenses for that. And with regard to the scientific evidence, the fact was that the testimony that was adduced at trial, the scientific evidence then brought before the jury, was dated. The techniques used were dated. But more importantly, the prosecutors had suppressed evidence that was favorable to her. In addition, this case has one of my absolute pet peeves in it, and that is allowing police officers to testify as expert witnesses as to the truth or falsity of statements made by a defendant. If at trial, I can't, as the prosecutor, ask the police officer, well, what did you think when John Doe over there said that he hadn't, killed his mom? Well, I could tell by looking at him that he was lying through his teeth. He can't get that in because that's a statement that goes to character, and it's also just incompetent. All of the studies indicate that cops are no better than 50% at telling whether or not someone's telling a lie or telling the truth. Now, it's perfectly okay for a police officer to show that someone lied. In other words, the defendant denies that he ever had a pistol. And so if he's never seen a pistol that was used to commit a murder, he's going to have a really hard time explaining how his fingerprints got on the weapon. And in that situation, what the expert is doing, coming in and presenting the fingerprints, is not commenting on his credibility. It's presenting counterfactual evidence that establishes that he's not telling the truth when he says he's never seen the handgun. That kind of evidence is perfectly okay. But what a cop should never be allowed to do is offer a statement that someone is lying based on some mythological belief that they can tell the difference between truth and lies. And all the studies in this area, as I said before, indicate that cops are no better at this than 50%. This is from the Journal of Criminal Justice and Law, a journal of law and public policy section of the Academy of Criminal Justice Sciences. Lie detection research has shown that observers who rely on cues alone correctly classify, on average, 54% of truth or lies. The accuracy of passive detection is a little bit better, just a little bit better than chance, and active detection, which requires gathering information, fact-checking communication content, strategically prompting deception cues, encouraging honest admissions, and discouraging continued deceit, is not much more effective. Even with gathering facts, research suggests that most people are still unsuccessful at distinguishing truths from lies at a level significantly greater than chance. And the reason we don't allow this is the same reason we take eyewitness testimony with a grain of salt. We also take the kind of statement about someone's veracity with a grain of salt because there is really no way to prove that based on the demeanor or the way they looked or how bad they cried or how badly they didn't cry, that might establish that they're guilty or innocent. It's basically a wild guess as to whether or not someone is telling the truth. In this case, like I said, a Texas Ranger claimed that Lucio was guilty because her demeanor and body language indicated she was guilty during the interrogation. Now, there are some body language panels here on YouTube, and I watch them frequently, and they evaluate the testimony of witnesses in trials and produce very enjoyable videos on that topic. They don't try to admit this evidence in a court of law where it has absolutely no business being admitted. I find it amazing that it took sending this back to the trial judge to get this answer. It seems pretty obvious to me that the appellate court could have made that ruling on the fly. This case is a perfect example of why I do not support the death penalty in most cases. First of all, if you are worried about recidivism among murderers, change the penal system. Make any person convicted of murder do 10 years at hard labor. They get 1 day a week off, 52 weeks a year, where they don't have to work, usually a Sunday. And that's the day they get to rest. All of the other days, they spend 10 hours a day in the yard with a big hammer making little rocks out of big rocks. If you made people do that, that would make 10 years a very, very long time to think about what you did wrong. The possibility that you would ever wish to reoffend to go through that again when you got out, that'd be pretty slim. But most important, the risk of error is very significant in a death penalty case. If you send somebody to the rock pile and they're there for 3 years, yeah, that's a significant punishment. But if you take their life by lethal injection, there's no way to go back and fix that. The guy on the rock pile, you can fix, you can pull him out of prison. But the person that you execute, you can't do anything about that. So it's important here. The police did not play fairly. The evidence didn't support the claims. The idea that the child had been abused because of the bruises when they didn't take into account the fall down the stairs, because children do fall downstairs. Children do hit their heads. We can be grateful that this innocent woman wasn't killed, but it does make you wonder how many other people are sitting on death row in similar situations. That's what I have for you today. If you have any questions, drop them in the comments down below. Like, share, subscribe, all those things we always ask you to do. And as always, if you have the opportunity today, do a kindness for someone. Drop the comments down below. Email me at the address above. After you do the kindness, come on back down. Join me down here at the beach. We'll talk about something else. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.